Hello everyone, and welcome back to another episode of the Darrell Brooks saga. In today's episode, we're gonna do one of the episodes you guys have been waiting for, and it's the 50-minute rant. And as you can see, in this poll that I put yesterday, I put a totally unbiased, totally fair, totally not weighted poll, and you guys decided that you wanted to see the 50-minute rant unedited, and that's what we're gonna do today. We're gonna go with the edited version up until the point when he starts talking, and then we're gonna continue with the edited one. So here's the guy. This is where we left off yesterday, and we're gonna continue with that. But before that, I just want to say thank you guys for subscribing. Please share this video, share it with other people. If you haven't subscribed, subscribe. I'm gonna go on a business trip next week, so I'm not really sure when I'm gonna be posting. I don't know if I'm gonna have to change my schedule. Maybe there's gonna be a day where I'm not gonna upload. So please subscribe and don't miss any of the videos because I may do it in the afternoon. So with that out of the way, let's get right into the video because
Please rise for the
it's a
witness
good one.
and for the jury as they leave the courtroom.
Look at his face. He's so disappointed because he doesn't get his. Oh my God, the tie. I'm not gonna.
Mr. Brooks, please wait. You may have a seat, everyone. To specifically address the repeated request by Mr. Brooks for the court to state the grounds, sir, I am not legally required to do that. Many times
Thank
it's
you.
very self-evident. Either the objections are baseless. Many of the hearsay objections are baseless. Your objection to hearsay is it's not hearsay. So that's why, to me, they're self-evident. I say sustained, and we go forward. So you need to be aware, sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury,
You're hurting yourself.
which I don't
like
feel is
always.
necessary for the reasons that I've already stated, that you're asking me to highlight my opinion on relevance and my determination on relevance. So going forward, you need to be aware of that. And I will caution you once again, sir, 90611 is the statute, mode and order of interrogation. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. A, make the interrogation and presentation effective or undue.
So basically, what she's saying right here is that he has power to do whatever she wants. Basically, not whatever she wants, but you know what I mean.
Embarrassment. And it goes on, but for purposes of what I'm going through, that's the most relevant portion of 90611. So when I give you the warning that under 90611, I will cut off your cross-examination, it's because you're violating 90611.
And
So-
is that a judicial determination that I violated 90611?
Yes.
I'm advising you, sir, it's not a specific determination as to anything that's happened thus far, just a summary of why I am relying upon 90611 throughout the questioning of witnesses and the presentation of evidence.
Your Honor,
So with that, we're going to continue. I'm going to have the state be ready with their next witness.
Your Honor, I'm not interrupting you. I'm letting you make a clear record. And
Mr. Brooks, you have actually.
I hate that he does that. He's like, I allowed you to do to say whatever you want. I didn't interrupt you, Pia. I
Interrupted me.
I just let you go through the whole citing of 90611 without saying anything.
I'm not asking for the parties to make an argument
Hey,
under
you just gotta shut up.
90611.
So
I'm
why read
advising
it?
you. Stop interrupting me, please. I'm advising you, sir, so that you have hopefully more knowledge and awareness as it relates to the statute that I've cited dozens of times
she didn't even need to do that. She just gotta say, dude, read 90611. Leave me alone.
during this
She's still explaining it to him.
Trial.
I'm well aware
Complaining
of what
about
I'm
it.
citing, Your Honor. Well aware.
All right, so-
No, you're
and I'm
not.
just seeking for the record to be clear. With all due respect, Your Honor, that's judicial misconduct because you're not allowing the jury who deserves to hear certain aspects of testimony. Like I stated yesterday, under the Sixth Amendment, I have the right to face my accuser, which means that I can question about clearly the plaintiff being the accuser. How come I can't question about if a witness may know or have had any prior interactions or any conversations or anything of the sort with the plaintiff who has yet to show their face?
I'm not going to have a debate with you over the law at this point. I've made my rulings as it relates to certain questions that you have asked and whether they're relevant, whether they're vague, whether they call for speculation, or a whole host of reasons that a question can be objected to. I'm not further going to address your position on
May I request a legal reconsideration of your ruling, Your Honor?
You interrupted me. I'm not done with what I was trying to say.
It was no way for me to know that because you paused. I'm sorry. I apologize.
Just because I paused doesn't mean I'm done.
But you paused for quite a while, so I wasn't sure.
In any event, sir, we're going to keep going. Any error you believe I've made, you can raise again on appeal if you are convicted, but we will proceed forward. Does the state have their next witness available? Please do not interrupt. I'm asking a question.
That's why I was just
Mr. Brooks, you're interrupting. Stop. Does the state have available their next witness?
We do, but could we please request a comfort break, Your Honor? I'm sorry, but we haven't gone about 2 hours now.
All right, that's
as long
fine.
as
We'll
they're out.
I had to listen to this guy for 2 hours. Please, let me go get a coffee.
Minute break. That's fine.
Thank you.
That's
You're
fair.
welcome.
For the record, Your Honor, we haven't addressed subject matter, jurisdiction.
We are off the record, Mr. All right.
Look
we
at
are
that. He's so...
back on the record.
I'm mad.
Then appearances are as they were before. State have their next witness available.
Yes, Your Honor.
All right, let's bring the jury back out.
I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party interviewer on special appearance on behalf of my client.
You already said that in the morning.
Can that be noted for the record?
It was noted this morning.
Thank you.
May it be noted again for the record so that we can keep the record clear and accurate.
Again, you don't have to say it. The moment that it comes out of your mouth, it's on the record.
The appearances are as they were this morning. They are no different. Bring the jury out.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't
She
been shown
addressed it.
any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later,
Thank you.
if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right, can
power?
you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks,
Should have just throw him out right there. We could have saved us an hour.
let's just wait
jurisdiction?
till the jury's out, please. I ask that you show that respect.
I will.
Thank
Your
you.
Honor.
Mr. Brooks, just make your statements. What do you want to advise the court today?
I
All
want.
right. We're gonna move to the little on-the-fly editing. Okay, here we go. 50 minutes. Let me stretch a little bit. Okay, here we go.
On the first state again for the record that I do not identify by that name, nor do I consent to being called that name.
You already said that.
Your Honor, with all respect, I'm merely asking you,
Merely.
do you have the full judicial power of the state, or is this military power?
I'm sorry?
What is that
I
nonsense?
don't understand what you're asking me, sir.
I'm asking, is
And on what
this,
legal basis are you making
I'm-
that request?
I'm asking for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that.
The thing is, he thinks that because he asked for something that he's entitled to get it. That's not how it works. I mean, you can ask for a puppy to be delivered to you, but they're not gonna do it, even though you asked.
Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My
The
court
judge is not
docket
gonna do it.
sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office,
He doesn't have to.
which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded,
He's guarded.
and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have
I read Article 6 or Amendment 6, I don't know how you call it. It doesn't say that. It says that you have the right to face the witnesses, and he's doing that.
yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond.
You just ask for those today, my guy. Give them some time.
In my docket sheet, I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked based on judicial determinations made by Your Honor.
There are questions that I'm not being asked? What? What questions they haven't asked you?
You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times, pretty much every day, every time I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get. And as we sit here today, I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that have not been provided. They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted.
Okay, he just threw around a motion to dismiss. Like, you have to do those in writing, my guy. You cannot just say that.
Everything that I'm saying, it has merit and it has validity.
No, it doesn't.
As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days.
What? Which ones?
There's so many things left to still be proven. The prosecution
trial
team
is not over.
Hasn't even proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just bar association members, or do they have state issued licenses? That has not been proven.
So he's saying that the lawyers that they have 20 plus years of experience are not licensed to apply their job?
I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet. There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven.
What?
Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over.
Wow.
No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by.
I already said that.
Inmate communication. Nothing gets certified that I get copies of when I clearly asked for them to be certified.
You already said that.
And to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to,
you want the case dismissed, or you want the judge to recuse herself? Which one?
Abide by the oath that you swore, which was in your oath, correct?
Your oath.
You swore to protect the Constitution of the United States. You swore to protect we the people. That is not being done here.
You are not the people. You're a guy. She is protecting the people.
If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding, because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect?
Incorrect.
Why there's so much on the docket sheet that should be on record that's not even in there? That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair, which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have.
Oh, you're going
again. I say I have the right to face my accuser. Where's the injured party? Who's making the claim?
Again,
I asked Your Honor.
I've said this on the comments, but how does this guy think that someone that is not alive anymore are gonna accuse him? So I don't see that how that happens.
Numerous times for your honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything.
No one needs to say anything.
Which you stated for the record a non-responsive answer. A non-responsive answer is an agreement, which would be a tactic agreement by you, Your Honor, that you don't have to answer these questions that you should be answering.
It doesn't.
I have that right.
Nope.
The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin.
It is.
But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question. The plaintiff should be present in this matter. Where is the plaintiff?
Again, to this point, for someone who claims to be so religious and has the Bible with him every day in court, he's asking this question for real? You know what I mean?
Who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter.
A witness did.
No one. Not one person.
One of the witnesses.
I have the right to demand that the court place in the evidence any unrevealed contract.
Okay.
Has that been provided to me? Have that been placed in the evidence? I would like to see it, which is my right.
But if there's not,
I have the right to inform the jury about the truth and their duty and their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know?
Because it's irrelevant.
They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to the jury. And frankly, it's a disservice to the court that they're not allowed to hear things that they should know, that they should be informed of. It's our right to inform them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed. And these are all valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf.
Do you want to be
guilty? As a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times.
Yeah, and they responded saying that they have jurisdiction. There you go. Now shut up.
I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions.
Just so everyone know, they both mean the same thing. Pro se and pro per is the same thing.
Imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney.
How we know?
In fact, the court is also aware that I only had 3 days to prepare for a trial that the prosecution has been prepared for a whole year.
Yeah, you did that to yourself. Why is the court? Why is something that the judge have to respond to?
We see these boxes right here. This box alone is 45 or 50 pounds full of so much information. I haven't even gone through half of it.
Okay.
It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that?
Thursday,
all
Friday,
the paperwork, all the
4 days.
the digital discovery and things of that nature. How can I go through all of that and be prepared in 3 days?
That's 4 days, my guy.
That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head.
That's clear bias. The fact that he fired his attorneys and only had 3 days before the trial is bias because he asked for that.
Winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least. At the minimum, it should be an adjournment because of that fact. At least to let me go through all the discovery.
No.
That was denied.
Yep.
No valid reason was stated for that when Your Honor knew there is no possible way, humanly possible, that I could be ready for a trial of this magnitude in 3 days. That's clear bias. I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again. Where's the injured party? Is the injured party present in court right now?
You already said that.
Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me? And because of that, Your Honor, the motion to dismiss should be granted.
No.
Based on that alone. There's no injured party in this matter. So who makes the claim?
The state.
Who? I have the right to put the judge on notice of my intent to appeal and any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down.
Let me check my notes.
I have the right to specifically reserve all of my rights, which I do at the beginning.
Yeah.
I have the right to say what I want and to be heard under the First Amendment. And when I attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention.
Never isn't my intention.
I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity.
They don't.
I have the right to object to any statement made by the judge or the prosecution. I've done that.
Yes, we know.
And been repeatedly shut down.
The thing is, you have the right to object, yes, but you don't have the right to. They just giving you the objection
without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit.
According to you.
Which is also my right. I have the right to recuse the judge at any time.
No, you don't.
Which is also a right.
More notes.
I have the right to a speedy and fair trial by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taking place for roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date. Way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial. That was denied, and I still don't understand how that was denied when it's clearly obvious that at minimum the venue should have been changed based on the fact of the magnitude of the matter. There's no possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were told something by someone that they may know.
Speculation.
The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County.
That will violate the Sixth Amendment, my guy. Like, let me just quickly. Well, I'm not gonna do it. But the Sixth Amendment says that the jury needs to be from there. If they move the case to Alaska, then the Sixth Amendment will be violated.
That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time.
Okay.
The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge, or I would have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional
I doubt that. I'm sorry, but I doubt that.
Relationships is and personal relationships. I've never had the cell phone number of anyone that was a personal relationship saved to my phone that I could reach out immediately when I learned something. that would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or hanging out time from time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record.
The thing is, he's appealing right now. Why is he appealing during
Again,
trial?
I go back to the Sixth Amendment again. In terms of when I asked for the motion for the evidence motion that I raised, that was denied without any explanation. That would be strictly to placing the evidence any unrevealed contract.
What if they're not?
That's under the
What
Sixth
if there
Amendment.
aren't any unrevealed contracts? What are they going to put in there?
Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything.
Yes, but no.
We also know that any law repugnant of the Constitution is null and void. We know that. There's still no basis for the motions being shot down. Why was I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted?
Because they're nonsense.
Which brings me to the motion to subpoena witnesses.
Right? What about that?
I did everything that was asked of me by the court pertaining to those subpoenas.
Yeah.
It was understood by the court that this is my first time ever having to do this.
Doesn't matter.
I didn't understand how to properly fill out the subpoenas, at which the prosecution volunteered that they would give assistance.
Yeah. They served them.
The only assistance I received was for them to check to see if it was filled out right.
What else do you want?
That was it. That doesn't amount to any assistance. I was still left
But you wanted to
fill it
fill
out
them
on my
for
own,
you?
and then when I did that, correction still had to be made, which would verify what I was saying. I don't know how to do this.
Doesn't matter. You decided to do it.
But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case?
You already said that.
So how could the subpoena not be filed?
It's filed.
And how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist?
It's an entity.
Which it was stated for the record that not only by a witness, a Detective Casey, that got on the stand and said on the record that is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity.
It is.
So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify?
I think it's the third
Will
time
they
that he
be allowed to
brings
be
this
in the
up.
courtroom? No, they will not, because they don't exist. Therefore, the claim doesn't exist. For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed. And at the very minimum, should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction.
You are the one that's talking about it, no one else.
That's been being asked for over a week. There's still no providing of license to practice law yet.
You already said that.
Not even by you, Your Honor.
He ran out of things to say.
Why was I not provided with a certified copy of your oath of office?
You already said that.
Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked.
How can you know that?
You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it is not certified. So how can I verify that that is the true oath of office that you signed?
You think she's gonna lie?
How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any legal reason why.
She doesn't have to.
I have the right to ask for that legally.
Legally.
I also have the right to call any witnesses to assist my defense, which is the main reason why I subpoenaed the plaintiff in this matter. I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people.
They protect the people from you.
From my knowledge, the design of the statutes of the law was written for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people.
And they did. And that's why they're drawn that way. No, it's
You know
not how you interpret the law, Mr. Brooks. It's not about you as a person. It's about the people. We the people.
Yes, Your
not
Honor.
you, the person.
Are you not a public servant? You also know that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name. Nor has it ever been my name, nor have I ever seen that name or individual.
Yes, you have.
Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that? What prompted the sudden change?
So, he's complaining that his name was in capital letters, and now he's complaining that it changed to regular. What? Isn't that what you
I
want?
still have filings that have all capital letters, which I state every time I come into your courtroom, Your Honor, that that is not my name, nor do I consent or agree to being called that name. I'm merely here as a third-party intervener on behalf of my client.
You already said that.
Did I accept for value in return for value? We go through this every time I
Even
come
he's tired of it.
every time.
Wait. Oh, no, never mind.
You bring up Illinois versus Allen when we had the issue of me being removed from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court. You stated for the record that you identified a 4th one, which is not cited anywhere in that case.
Illinois versus Allen says there's no one way of doing that. So there's more than 3, my guy.
It's not cited anywhere. So the question would be, how did you come up with a 4th option that's not written in that case? Did you take it upon yourself to add this 4th option to justify denying me my constitutional right by being present? You could have done the 3 that were stated. Any one of the 3 you could have done that were stated in the case.
So one of the 3 is remove him from the court, period. So he wants her to do that?
Nowhere does it say you can create a 4th option. Not upholding my constitutional rights. I'm sure you know about Title 18, USCS 2381, which states that it's treason not to uphold your oath of office.
I read that. I looked that up. It's not. That's not what it says. Look it up. It's not. That's not what it says. It speaks about treason, but it never says that's nothing about oaths.
Treason. You repeatedly make judicial determinations that clearly prejudice my defense. And then when I question you about, are you making judicial determinations, I'm repeatedly shut down.
Good. Are you done?
Which leads to today.
All right, we're in today now. Great.
The constant push not to have an informed jury.
You already said that.
Not giving legal valid grounds on objections. Not noting objections for the record to make sure that the record is clear.
He doesn't need to.
I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing a claim.
Right?
But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias. And it prejudices my defense. You know also that you have an electronic filing system. I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few seconds right in front of my face. When the prosecution needs something filed, it's filed immediately. I have to wait, or I have to wait to the next day. That's a clear bias and a clear prejudice to my defense. Obviously, the court knows that I'm not privileged to the same filing system.
Yeah. So?
Which brings me to the reason why I brought up the issue of assistance of counsel. Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say
you waive that.
Anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things.
They're not.
You, Your Honor, gave me paperwork that was a waiver of counsel.
Yes. A waiver that, by the way, on the bottom, it says it cannot be modified. None of these words can be modified. Now let's hear him.
Know that any contract can be altered.
That's not true.
If I don't agree to certain terms.
Not a contract. It's not civil.
I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion. Get things filed in a timely fashion. Get motions together in a timely fashion.
Not how it
Make
works.
preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it.
He had to file it.
That is in the record.
Yeah.
I have copies of the same paperwork that you accepted. So when you accepted that, with no objection, that becomes a tacit agreement.
Tacit agreement. This guy.
But yet, I'm still forced to come in here with zero help.
You decided that.
I think it's clear that prejudiced my defense.
It does, but you choose that. You decided that.
Knowing that the prosecution has everything that they need for this matter at their fingertips.
You were told this before then.
And I have to jump through every hoop possible to even get things filed in a timely fashion. It was stated for the record that the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day.
No, you're
not
not
given the privilege to access everything that I should be able to at the time.
You're in court for like 9 hours, my guy. How are you locked down 22 hours?
Time that I should be
if
I was general population. Arrangements could have been made months ago for me to be at least in some form general population with an upcoming trial. Reference was made to being able to use LexisNexis or whatever it's called. We call it the law library.
Library?
The easier way to describe it.
Library?
I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room, you can't access the law library, which is on tablets. We are not allowed to have those tablets in our cells.
No, you're going to be on Facebook.
That prejudiced my defense. How can I work on my case? How can I look up certain case laws? How can I do any of this if I don't have full access to it? I even suggested some type of order that could be made by the court to allow me more time out of my cell, or to talk to jail administration about allowing me more time out of my cell to be able to use those when needed. And to be frank,
you're not frank. You're
in a proceeding of this magnitude. There should not be even a time where I don't have access to the materials that I need. If I'm not in the courtroom or sleeping, I should be awarded the time to work on this case, seeing as how I only had a couple days to prepare for a trial of this magnitude.
That was on you. No one forced you to do that.
Which brings me back again to the change of venue again.
Even
right now with trial going on, there's still political ads being shown every day that reference this.
How do you know?
There's still talk throughout the jail about it. There's been a ton of hate mail received to the jail since the beginning of this.
Good.
It did die down for a little bit, but it picked right back up the closer we got to the trial.
Oh.
Hate mail that comes from people right here in the city of Waukesha.
Yeah. You did something horrible
which
there.
Gives more
credibility
to the venue needing to be changed.
Birthday cards?
Yet and still, that was denied. It's impossible for impartial jury to be found in this county, and that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That would be accurate.
So they can be impartial or they cannot, my guy.
But with the level of scrutiny that this whole incident has,
you just say that they can't, and then he says that they can. So which one?
The Facebook groups, the constant. There were Facebook groups created because of this.
How do you know this? You have Facebook in jail?
The reporting live stream on Court TV has comment sections.
How do you know that?
Where a lot of insensitive and nasty things are said. The sheer insensitivity of some of the things that are said.
And this guy talking about insensitivity when we know how he's been to the witnesses, to the victims, and he's talking about insensitivity? What?
I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is, that I have children too. Family too, loved ones too.
No one said you don't.
That also have been ridiculed and had their names drugged to the mud and have threats towards them.
They have to thank you for that.
Loved ones that had to leave their home because they were getting threats thrown through their mailbox. children that didn't feel safe going to school because they were getting bullied behind what was being said. And that's not to sweep anything under the rug whatsoever.
So, why do you bring it up?
To constantly say and report this incident as attack, terrorism.
No one says terrorism.
It's unfair and it's insensitive.
It's just an attack.
It's a definite tragedy. Definite. And that will never be swept under the rug.
Right?
There's always going to be healing that has to take place. It's going to be difficult. And that should not be swept under the rug whatsoever. But it's very insensitive and unfair to not recognize that there's many other victims that never is talked about.
You want more victims, Darrell? You need more to your record? What kind of statement is that?
And for people to paint a certain picture, mostly from this county, to put this picture out there, it's not only hurtful, but it's insensitive, and it's not true.
Okay. What do you want
I'm
me
sure
to do
the
about
court
that?
read through the motion for change of venue. I'm assuming, though it was a lot of paperwork in those motions, I think it was obvious that the venue should have been changed. Obvious. It's too many connections and it's too close. It's too close. If there was any chance for a fair trial and an impartial jury, it should not have been in this county. But yet it was denied without any validity. Zero.
Zero.
There's so much bias that's going on that
how much do I have left? Please save me. Save me from this. My brain is shrinking.
and even with all this, for the record, we still have no proof of jurisdiction.
And all of this.
We still have no bond on file in the docket sheet.
How long do I have left? Save me. I think it's close.
We still have no plaintiff. We still have no claim. We're not sure of the relationship between you, Your Honor, and a father of one of the...
Cut him off. He's
just
just saying stuff now.
We're not clear on that relationship, no matter how well prepared the speech was, because it was a prepared speech. That was obvious.
Yeah, some people prepare for what they say, unlike you.
Where's the proof? I just asked that same question. Can an affidavit be given that there is no bias, no conflict of interest, and no interest in the outcome of this case. There still is no proof if you hold the full judicial power of the state, or is it the military power?
Mr. Brooks, I've given you about
All right.
3 minutes
We're
to
done.
make your various
Did it.
arguments.
Oh.
You've now repeated yourself a number of times.
That was
so I'm going to
painful.
turn to the state to see if they have any response. Go ahead.
Thank you, Judge.
All right. I'm gonna. My brain is done with this, so we're gonna come back tomorrow with the rest of the day. But that was all that's all that I can suffer at one time from Darrell Brooks. They were just nonsense. It was just baseless. It was just speculation. It was bad, and none of this is gonna stand. So thank you so much for watching. Thank you for the 500 subscribers. I'm working on another secret video that I've been hinting at the comments that I'm gonna release over the weekend, I think, if everything goes right. If not, I'm sorry. That's why I don't want to talk about it too much, because I'm not sure when it's gonna come out. But be on the lookout for that. I'll see you guys tomorrow with more of this. Have a great day. Bye bye.